Judgment in the appeal, the application by Denise Brewster for judicial review.
Lord Kerr will explain the decision of the court.
Many employers provide a pension for surviving partners of their employees. Translink, which is the principal public transport company in Northern Ireland, is one such employer. William Leonard McMullan, known as Lenny, had worked for Translink for 15 years. He and Denise Brewster, the appellant in this case, had lived together for about 10 years. They had not married, but they intended to, for on Christmas Eve 2009 they became engaged. Tragically, only 2 days later, Lenny McMullan was dead. His death was sudden and unexpected. He was only 43 years old. Under the scheme that Translink operated at the time of Mr McMullan's death, a surviving partner could be paid a pension even if she was not married to the employee who had died. But that only became payable on certain conditions. Firstly, she and her dead partner had to have lived together for at least 2 years before he died. Secondly, he and her partner had to make a declaration that he wanted her to receive a pension. This was called a nomination. Thirdly, the cohabitation period of 2 years was required to have taken place before the nomination was made. Although Ms Brewster believed that Mr McMullan had made a nomination, no trace of this could be found, and the appeal before us therefore proceeded on the basis that none had been made. And that meant that Ms Brewster did not receive a pension. Now, the requirement of a nomination did not apply to those who were married or who were in a civil partnership. And this appeal has been principally concerned with the justification for its existence in the case of cohabiting partners only. A number of things were agreed. First, it was accepted that expectation of a survivor's pension qualified as a possession for the purposes of Article 1 of the First Protocol to the European Convention on Human Rights and Fundamental Freedoms. That provides that every person is entitled to the peaceful enjoyment of his or her possessions. Second, it was agreed that Denise Brewster came within Article 14 of the European Convention, and that provides that the rights which arise under the Convention are to be secured without discrimination. Third, it was agreed that a surviving unmarried partner is in an analogous position to a surviving married partner or someone who is in a civil partnership. And finally, it was agreed that the refusal to pay Ms Brewster a pension interfered with her right to peaceful enjoyment of her possessions. The critical question was whether that interference was justified. Ms Brewster applied for judicial review of the decision not to award her a pension, and the judge who first heard her case thought that this indeed did amount to unjust interference with her rights under the First Protocol and represented unlawful discrimination. He said that she should have her pension. The case was appealed, and a majority of the Court of Appeal in Northern Ireland reversed the judge's decision. They said that the interference was justified. Ms Brewster appealed to this court, and we unanimously allow her appeal. Originally, the requirement of a nomination procedure in Northern Ireland was said to be necessary because there was a similar requirement in other parts of the United Kingdom, and it was suggested that consistency of application of requirements for entitlement was desirable. But the schemes in England and Wales and in Scotland were changed to remove that requirement so that could no longer be put forward as justification. Then it was suggested that the scheme would be more workable if the nomination was preserved, but no evidence was offered to support that suggestion. It was also suggested that there might be some actuarial advantage, but again, no evidence to support that claim was forthcoming. Nor was there any evidence to support another claim, namely that administrative costs would increase if the nomination procedure was abandoned. To the contrary, there was nothing in the Great Britain experience after nomination had been dispensed with to suggest that any of these eventualities had actually accrued. On a more general plane, it was argued that in the socio-economic field, courts should be very slow to interfere with decisions of government, and the scheme under which the nomination procedure was required had been produced by the Department of the Environment in Northern Ireland. Where a conscious, deliberate decision is taken by a government department about the distribution of finite public resources, a court should, as a matter of principle, be slow to interfere. But that is not the situation here. In this case, the reason for including the nomination procedure was not to save public money. It was to make the scheme the same as in England and Wales and Scotland. Of course, it is now suggested that savings might be made if the nomination procedure was retained, but as I've said, no evidence to back that claim up has been produced, and it does not appear that significant further expenditure has been required in the rest of the United Kingdom when the procedure was abolished. So we decided that no justification for the interference was shown, and that therefore refusing Ms Brewster a pension was unlawful discrimination. We said that she's entitled to receive a pension and that the nomination requirement should no longer be applied.
Thank you. The court is now adjourned.